Hello everyone, welcome to the 200 Q&A practice. We're going to start off with defense questioning. Ready? Was he capable of knowing or understanding the nature and quality of his acts with regard to shooting his rifle into this home? As far as I could tell, and with the suppositions that I stated, he was not able to know the nature and quality of his acts at the time. Would this opinion be based upon a reasonable medical certainty? A reasonable medical certainty, yes. There is no way that you could strike that. Is there any way you could bring us an image of the devil into this courtroom so we could see one? I don't know of any. During your examination of Mr. Johnson, did you have any indication at all that he was faking or making up his story? No. In your past experience, have you examined anyone and came to an opinion that they were faking or making up a story? Yes. Do you feel if Mr. Johnson was faking it or making up a story, you would have been able to detect it? I'm not really certain in this case. Based upon, I believed what he said, but I couldn't say with any real degree of certainty that everything he told me was true. Now, if you had examined Mr. Johnson shortly after the incident took place, would you have been able to be more certain with regard to your opinion? I should have been able to be much more certain. And if the examination had revealed to you literally the same facts that you had on the date of your examination, would your opinion be the same or would it be different? My opinion would be the same if he appeared the same when I examined him immediately after, yes. Doctor, do you have an opinion as to whether or not the events that took place have any connection whatsoever to this hallucinosis that Mr. Johnson was suffering? I have to assume that they did, that they were the outgrowth of it, and that in effect what he was doing within his hallucinatory and delusional state was either protecting himself and or his wife and daughter. After investigating and studying Mr. Johnson's past behavior pattern, do you feel that this type of behavior pattern indicates that he would have engaged in this type of conduct without the hallucination? It doesn't appear that he would have. No, there is no history of this kind of behavior in his past that I could elicit. At the time that you examined Mr. Johnson, were you aware of any other psychotic examinations or psychiatric examinations that Mr. Johnson had undergone? No, I don't believe I was. I have nothing further. Okay, counsel. Thank you. Dr. Klatt, I believe you indicated that based on the defendant's past behavior pattern, you found no history of this sort of thing happening. That's right. And I believe that you indicated in your report that in general, the defendant is not moody, but he is inclined to be moody when drinking. He is not inclined to be violent, however. That's right. Do you recall that comment? And this was based on information that you obtained from the defendant. Is that correct? That's right. He didn't tell you about any situation where he became violent or very aggressive. I believe I indicated the other way that although it wasn't included in my report, he may have told me an incident of slapping his wife, but other than that, I don't know of any. Other than slapping his wife, you heard nothing about him getting involved in fights with police officers or waking up with his lips swollen after presumably a drunken altercation the night before? No. Now, I believe you have indicated earlier to us that you cannot attest to the mental condition at the time of the incident. Is that correct? Yes, not. Since I wasn't able to evaluate him at that time, I have to make a supposition based upon whatever information I have. And the information that you get, unless you have an opportunity to confirm it, the information you get regarding the defendant's state of mind comes from the defendant, from the written reports that I read, and a description of the nature of the crime itself. And when he told you about the destruction of the house, I noticed that you put down here, the police report tends to confirm this. Is that correct? Yes. And then he told you that he doesn't remember leaving the house. You took that as a fact, information that you took on face value as being correct, that he did not, when he talked to you, remember leaving the house. I took it on face value that when he talked with me, I didn't take it on face value that after he was arrested, that he didn't remember, because I think there were some statements to the contrary. I wasn't surprised, nor did I think this was particularly significant, since this is typical of alcoholic blackouts, that sometime later they may not remember what they do, although at the time they may remember what they are doing. Okay, I'm going to switch transcripts. Okay, this is going back to defense. Officer Girk Did you ever indicate at any time that it would be beneficial to Mr. Heron's welfare? Strike that. Did you ever indicate to Mr. Heron that it was a good idea for him to turn himself in and get this matter cleared up? No, sir, I did not. Did you ever indicate to him what the penalties for robbery were? Yes, sir, I did. What did you advise him? I advised him that armed robbery was the second most serious crime in the California Penal Code. It carries a sentence of 5 years to life. He stated he still wanted to talk to you after you told him that. This was after I had already spoken with him. Did you discuss the matter of penalties with him before the time when he had made a statement to you? No, sir. Did you ever indicate to him when an attorney would be provided for him? No, sir. Did you ever advise him that he had the right to make a telephone call right away, to phone an attorney if he desired to do so? He was advised of his rights. Did you ever advise him of the right to make a phone call right away? Objection irrelevant. Sustained. On the grounds it is not relevant to voluntariness. Yes, it would seem to me if you are going to talk to an officer and give up the right to have an attorney, that should be an intelligent decision only after full advisement of how immediate these rights are, whether or not they attach at this point in time or some later point in time. The court doesn't know any such right. I believe that in Miranda, the court stated that the person has a right to have an attorney present throughout any questioning if he desires to talk to the police with the assistance of counsel. That right was acknowledged by the witness, but not in the form in which counsel has suggested in his question. The right to have one present before any questions are asked implies that he has the right to have one now, so that particular area is solved. You indicated that Mr. Heron stated to you that this matter of pulling the robbery had been discussed by himself, by Billy and Steve. Is that correct? Yes, sir. He said Steve had an idea of where a good place might be to pull such a robbery? Yes, sir. After Steve had made that comment, they went to this location. Is that correct? Yes, sir. Did he say that they had definitely decided to commit a robbery at that place, or did it depend upon certain contingencies? They didn't state. They stated that they had discussed pulling a robbery. They also indicated they didn't want to pull a robbery with customers inside. Is that correct? Yes, sir. They also didn't want to pull a robbery unless there was a fair amount of money to be gotten. Is that correct? They didn't state any certain amount of money. They wanted to check and see how much money was in the register before they committed the crime? Yes, sir. In other words, if there was no money in the cash register, they presumably would not want to commit the crime. They did not indicate that. In other words, the impression you got is that regardless of whether there was any money or no money in the cash register, they would have attempted to commit a robbery. That was my impression. Even though he stated his purpose to go in was to determine how much money was in the cash register? Yes, sir. Was Mr. Heron to give some sort of signal after he had determined how much money was in the cash register? No, sir. Wasn't that the strike that? Did you question him as to what the purpose of his ascertaining how much money was in the cash register, what the purpose was? No, sir. Weren't you curious as to what the purpose was if they weren't going to commit the crime regardless of whether there was any money? Objection argumentative. Sustained. Your Honor, I think you have a situation here where it's obvious that one person was to make a determination whether or not there was enough money in the register to warrant the commission of such a crime. What you have is a mere preparation, and that it seems to me to be fairly obvious that the purpose was to give some sort of a sign, and there is no indication that such a sign was given. In other words, the plan was not followed. The other two people came in on their own and committed the crime. That's where I am trying to establish. You think that's of some assistance to the defendant and has some relevancy on the question of whether or not he's involved? I think it goes to the question of whether there was active participation or mere participation on his part. Overruled. Answer the question. Could the question be read back? I think you can ask it easier, counsel. Weren't you interested in finding out what the purpose of or purpose was of Mr. Heron's going into the store to find out how much money was in the cash register? I'll object again. It's irrelevant whether he was interested or not. Well, it's getting to the issue. Overruled. You may answer. Yes, it was obvious why he was going to check the register. Why? To see how much money was in the register. Were you interested in knowing why he was interested in knowing how much money was in the cash register? No, it was obvious to me why he was checking the register. Why was that? To see how much money they were going to get. Could you explain that answer? Well, not an exact amount of money. In other words, they were checking the register to see how much money was in the register, whether it would be a big hit, so to speak, or an average hit. It was obvious to me they were checking the register. Okay, wasn't it also obvious to you, Mr. Girk, that if the cash register was virtually empty, that he would decide if it was worthy or not worthy or worthy of risk? Objection, it calls for speculation. Sustained. Officer Girk, are you working any special detail at the present time? Yes, sir. What is that? The robbery detail. You are familiar with some of the modes of operation employed by robbers? Yes, sir. Isn't it a fact that you found your experience that if a robber or someone who is contemplating a robbery decides that the amount to be gained is not worth the risk involved, the person will not commit the robbery? Objection, Your Honor, calls for speculation. Sustained. Okay, that concludes our Q&A practice for the 200 class. Have a great day.